when the state could decide who deserved to live and who deserved to die. A man named Makwanyane stood before the law. He had committed a terrible crime. There was no denying it. And under the law at the time, his fate was already decided. Death. But something had changed. South Africa was no longer the country it once was. A new constitution had been born, one built not on fear, but on human rights. So the question was no longer just about one man. It became something far bigger. Should the state, in a society built on dignity, have the power to take a life? The case reached the highest court. The Constitutional Court of South Africa. A court tasked with defining what this new South Africa would stand for. The judges did not ignore the crime. They did not excuse it. But they asked a deeper question. What does justice look like in a society that values human dignity? Because if every life has value, then that principle cannot disappear when someone does something terrible. The court looked at the Constitution, at the right to life, at the right to dignity, at the promise that no one should face cruel, inhuman, or degrading punishment. And slowly, a new truth became clear. If the state takes a life, it denies everything the Constitution was meant to protect. So in 1995, the court made its decision. The death penalty had no place in a constitutional democracy. Not because crime is acceptable, but because dignity is. That day, South Africa made a choice. Not about one man, but about what kind of nation it would be. A nation where justice does not come from taking life, but from protecting it.